The government just crossed a line. Imagine sitting in your own home, no warrant, no warning, and suddenly law enforcement walks through your door and opens fire. This isn't a dystopian movie, it's the real foundation of a Supreme Court case now being heard. One that could redefine your Fourth Amendment rights and your protection against warrantless firearm confiscation. The case builds on a rare 9-0 ruling that already struck down one abusive search. But now, Montana wants to expand that power, and the Supreme Court is about to decide whether your front door is truly sacred or just a suggestion. If you value your rights and your home as your last line of defense, you're in the right place. This is Survival Firearms, and we break down every court battle threatening your rights. Subscribe now, because this decision could change everything for gun owners like you. Chapter 1. A case that could rewrite Fourth Amendment protections. The new case heading for oral argument is Case versus Montana, and it's not just about one man's rights, it's about all of ours. It questions whether law enforcement can enter your home and seize firearms based on vague fears, without probable cause and without a warrant. The case could reverse or expand one of the most important decisions in recent history, Caniglia versus Strom, where the Supreme Court ruled 9-0 against warrantless entry. Case versus Montana centers around Trevor Case, whose ex-girlfriend reported vague concerns to police. Officers arrived at his home, looked through windows, and found no immediate threat. Yet, without a warrant or response, they entered anyway and shot Case inside his closet. He survived and is now asking the court to suppress the gun and evidence taken. The Montana Supreme Court sided against him in a 4-3 ruling. Now, the Supreme Court of the United States will weigh in. This isn't just a local issue, it's a potential national standard affecting how far police can go inside your home under the label of emergency. Chapter 2. Why gun owners should be alarmed. This case doesn't just involve the right to be secure in your home. It's about whether your firearms can be taken without due process. The state argues officers acted under a so-called emergency. But what if that emergency is based on assumption, not actual threat? Officers never saw Trevor Case behaving violently. His ex-girlfriend couldn't even recall what was said. No one had a warrant, yet they entered the home anyway. The officer who shot him admitted he just let one fly. This raises a critical question. What stops the same thing from happening to you? Gun owners have always relied on the Fourth Amendment to secure their homes. But this case asks, is that protection still real? Chapter 3. Caniglia versus Strom. The precedent. They're trying to twist. The case references a 2021 Supreme Court ruling, Caniglia versus Strom. In that case, officers lied, entered a home, and took firearms without a warrant. The court ruled unanimously in favor of the homeowner. So why is Montana trying to twist that decision? In Caniglia, a husband placed a gun on the table during an argument. The next day, officers entered the home after the wife gave permission based on misinformation. The homeowner had refused consent, but officers seized his firearms anyway. The Supreme Court ruled 9-0 that the community caretaking exception did not apply. That ruling reaffirmed that homes deserve the highest Fourth Amendment protection. Now, Montana is asking SCOTUS to scale that protection back using Caniglia as a starting point to justify broader exceptions. Chapter 4. Emergency aid or excuse. Montana argues officers entered based on an emergency aid exception, not needing a warrant if they believe someone is in danger. But that legal path has limits. It requires probable cause, not just a feeling or vague concern. And that's where this case crosses the line. Trevor Case was not threatening anyone when officers arrived. They waited 40 minutes outside before entering, not exactly urgent. No sounds of distress were heard, and no one else was in danger. Yet they still entered, armed and without a plan. One officer fired through a closet curtain without identifying a target. This is not emergency aid. This is a legal workaround that, if accepted, could give the government sweeping power to ignore the Constitution. Chapter 5. The Trump DOJ steps in, but whose side are they really on? The Trump administration has entered the courtroom, but surprisingly not in defense of Case. They filed a brief in support of the state of Montana, arguing for a lower legal standard when it comes to emergency entry into your home. The Trump DOJ says these searches should only be held to a reasonableness test. That would mean officers don't need probable cause to enter. Reasonableness is vague and easily manipulated. Even Montana and the Trump DOJ disagree on how it should apply. Case's legal team warns that this could gut the Fourth Amendment altogether. If SCOTUS sides with Montana and adopts this test, it could create a national precedent that erodes gun owner protections starting at your front door. Chapter 6. The Ghost of Caniglia returns. The defense in Case versus Montana is leaning hard on a precedent, Caniglia versus Strom. That case struck down the community caretaking doctrine and reinforced the need for probable cause. Coniglia involved a husband who was taken to the hospital for evaluation. Police lied to his wife to gain entry and confiscated firearms without a warrant. The Supreme Court ruled 9-0 against that action. They made clear that the Fourth Amendment requires more than concern, it requires cause. Trevor Case's team wants this new ruling to reaffirm that message. Concern isn't enough. You need a real, provable emergency. Chapter 7. A house, a curtain, and a bullet. The events in Trevor Case's home were dramatic, but also murky. According to officers, a curtain moved, and within 0.4 seconds, a shot was fired. They claim they saw Case's face and a black object, but Case was hit in the arm and abdomen without clear identification. Officers later admitted they may have reacted instinctively. One said he let one fly after seeing the curtain move. Trevor Case says this proves they acted recklessly, without cause. His legal team argues the evidence should be thrown out, starting with the warrantless entry itself. Chapter 8. The battle over reasonableness versus probable cause. One of the most critical legal fights in this case is over which standard police must follow when entering your home in an emergency. Is it probable cause, which demands hard facts, or just reasonableness, a vague term that opens the door to abuse? The Trump Department of Justice and the state of Montana argue that in emergency aid situations, officers only need a reasonable belief that something is wrong, not actual proof. They claim that probable cause is too restrictive and could delay help in fast-moving situations. But Trevor Case's lawyers push back, warning that this so-called reasonableness standard is dangerously broad and unpredictable. They argue that the home deserves the highest constitutional protection, and loosening the entry standard would violate the Fourth Amendment. This chapter isn't about technical legal language. It's about whether police can burst through your front door based on a gut feeling. And if the court sides with Montana, the definition of privacy inside your own home could change overnight. Chapter 9. Even the government can't agree on the standard. Here's where things get messy. Even the two sides supposedly working together can't agree on how this lower reasonableness test should work. That's a big red flag. The Trump DOJ and Montana both support emergency entry with less than probable cause, but their briefs contradict each other on how that test should be applied. One wants a broad interpretation based on officer discretion. The other seeks a narrower framework with clearer boundaries. Trevor Case's legal team pointed this out to the justices, emphasizing how inconsistent and unstable this standard really is. If lawyers for the government can't explain it, how are law enforcement officers supposed to follow it, or citizens supposed to defend against it? The fact that even the proponents of this test can't define it proves how dangerous it is. The court is now being asked to approve a rule that could shift based on interpretation, and that's exactly the kind of legal vagueness the Constitution was designed to prevent. Chapter 10. What's really at stake for gun owners nationwide? This case doesn't just affect one man in Montana. It could set the stage for how law enforcement interacts with every gun owner in America, especially inside their homes. A ruling in favor of Montana could weaken the legal wall protecting your home from unwarranted entry and firearm seizure. It could open the door for police to act on incomplete reports, feelings, or community tips with no need for probable cause or a warrant. And if that becomes national precedent, every future case could cite this one to justify more aggressive tactics. The original Coniglia v. Strum's ruling was a 9-0 win for privacy and gun rights. Now that line is being tested. This case is about more than just search and seizure. It's about defending the foundational principle that your home is your castle, and that no one, not even the government, gets to violate that without strong, lawful justification. What happens here will echo far beyond Montana. Defend the line before it moves. At Survival Firearms, we believe the Constitution doesn't bend for convenience. The home is sacred. The rights of gun owners are not negotiable. Subscribe to the channel to stay ahead of every legal battle that threatens your freedom. Because if we don't draw the line, someone else will, and next time, they might draw it through your front door.